Okay, Chris Morgan, whenever you're ready.
Welcome to today's program titled Retirement Plans, Funding, Compliance, Fiduciary Liability, and Litigation Risks in a Post-Election Landscape During COVID-19. At this time, all participants are in listen-only mode. For those of you who are logged on in the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. If time allows, the speakers will address your questions at the end of the presentation. If your question is not addressed during the presentation, one of our speakers will follow up with you via email following the program. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write down this code, as it will not be reread and it is required for CLE credit. CPE credit will also be available for today's program. To earn the available 1.0 CPE credit during today's webinar, you must listen to at least 50 minutes of the presentation and answer at least 3 polling questions. The polling questions are a series of questions meant to confirm that you are actively attending this webinar. Please note that you must be logged in individually to receive credit for today's webinar. If you are attending as a group, only the individual who is logged in will receive credit. If you've completed the requirements, your certificate will be sent to you a few days after the webinar. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the program. At this time, I would like to turn it over to Candace Quinn. Candace, please go ahead.
Morgan, and welcome everyone. We're delighted you could join us today for this webinar brought to you by Seyfarth, Mazar, and BPAS Actuarial Services. Hello, I'm Candace Quinn. I'm a senior counsel at Seyfarth, and I'll be joining the panel discussion today. And our topics will include retirement plans, funding, compliance, fiduciary liability, litigation in a post-election landscape during COVID-19. Our panelists will include Vincent Spina, President of BPAS Actuarial Services, Kristen Walters, Partner at Mazar USA, Ben Spader, Senior Counsel at Seyfarth, and Ada Dolph, a Partner at Seyfarth. To kick the presentation off, I'll turn the program over to Vincent Spina, who will discuss interest rates, its history, effect on pension plans, and expected future investment returns. Vincent?
Thank you so much, Candace. We'll get started. By training, I'm an actuary. I've been working in the pension field for over 30 years. And during that time frame, the interest rate environment has changed dramatically. So I'm going to take a few minutes, talk about how we got here, the effect on both plan sponsors and participants, and then briefly talk about what's the path forward. So if we can go to the next slide. So this is just simply a chart of the historical Federal Reserve discount rates. And it goes back to 1950. And if you go back to the 50s and even the early 60s, you see rates that were in the 2 to 4% range. And then for those of us who came of age in the late 70s and early 80s, we all remember high inflation, which led to the Federal Reserve raising interest rates dramatically to squeeze inflation out. And then since then, it's been a kind of a stair step down, with certain times when interest rates have spiked up when the Fed has tried to put more bullets back into their arsenal. So when we go on to the next slide, it actually illustrates it a little bit better. This is the historic yield on 30-year Treasury notes, risk-free rate of return. And if you look back to the early 80s, those rates, the 30-year Treasury spiked in 1981 or 82, right around there, at 15.5%. It's kind of dramatic. What happened was the bond market, as well as the Federal Reserve raising interest rates, the bond market said, hey, we need to be paid more for our money if we're going to lend it to the government. And as a result, if you were an investor in the early 1980s and bought a 30-year Treasury note yielding 15.5% and then reinvested along the way you actually did better than if you had been in the stock market. I can show you the data on that, which is kind of astonishing, right? Because 30-year treasuries, in theory, are risk-free. But you can see on this graph, this shows it even better, that it's been a stair step down in rates since the early 80s. Every time the economy gets soft, the Federal Reserve goes to its arsenal, lowers interest rates to prop up the economy, and it's been repeated time after time over the last 40 years. So if we can go to the next slide. This is also then illustrative, comparing the 30-year treasuries to 10-year treasuries to the cost of borrowing to buy a mortgage or to have a mortgage, right? The 30-year, the green line is the 30-year fixed rate mortgages. And I had friends whose parents were builders back in the early 80s. When interest rates spiked, you can see the 30-year mortgages were close to 20%. And builders of single family homes went like a year or 2 years without being able to sell any properties because interest rates were so high. And that's what the Fed was trying to do, actually. They tried to squeeze out inflation. And then since then, we've seen rates continually come down. It's hard to believe where we're at. Who would have ever thought you'd see mortgages with a 3% handle on them? So we can go to the next slide. So the summary of this is, if you're borrowing, low rates are great. However, if you're an employer who has a fixed payment stream as a promise, meaning a pension plan, low interest rates make the value of those promises, those payments, much more expensive. Why is that? What is a pension plan? It's a stream of payments off into the future, and the liability we measure as actuaries is that discounted cash flow. And the way it works is, the lower the interest rate, the higher the liability, because you don't have as much discounting taking place with a lower interest rate. So, and at the same time, if you're a retiree and you're in a low interest rate environment, it creates a true challenge for those who are dependent on savings to supplement their income, whether it's Social Security or a pension benefit, or if they've got 401k, what do you do with the 401k rollover to an IRA? So we can go to the next slide, please. So here's a very simple example. If I took a pension plan that existed in 1985, and in this example, the interest rates used to discount, benefit payment streams, the interest rate used to come up with the present value was probably around 8%. And the mortality table we used was one that was played at the time back in the mid-80s, the 1983 GAM table. And at that liabilities, we added it all up, we got to $200 million of liabilities. If we fast forward to 2020, the discount rates being used to value liabilities are 2.66%, roughly 2.5%. And suppose we had even just used the same mortality table, that same pension plan, nothing else being different, same payment stream, that same pension plan would have liabilities that are close to $500 million, more than twice as much, just because of that interest rate change. And at the same time, we're all living longer collectively. And I'll leave you with this as well for you to, keep in mind when you're planning your own retirements. I tell clients all the time, if you've got a couple who are 65 and 65, two people who are 65, it's even money. It's 50-50 that one or both of them are going to be alive at age 90, 25 years off into the future. That's how long collectively we're living. Now, we all know people who didn't get there, but this is in fact how it's playing out, right? So the mortality tables have been updated to reflect longer life expectancy, and that's that last column. So that the same pension plan, nothing's different other than the interest rate environment and the fact that people are living longer. The liability associated with that same pension plan, 1985 would be 200 million, and today would be over $500 million, more than a double, almost a 3-time increase, just because of the economic environment and the fact we're living longer. So if we can go to the next slide. So for individuals, it's a similar kind of story. Suppose I wanted to have lifetime income of $1,000 a month. Back in 1985, you had interest rates that were close to 10% in terms of being able to price annuity contracts. The cost of that $1,000 a month for life, guaranteed income, from an insurance carrier was around $97,000. And you fast forward it to today, with interest rates in the low twos, right around 2%, with this improved mortality, that same $1,000 a month for life to a woman who's age 65 will cost over $200,000. Twice as much money needed to provide that same income stream into the future. So a very challenging time for retirees. So we go to the next slide. So I'm going to give you an example. If you are associated with a company that has a pension plan, or if you're involved with overseeing a pension plan, either sitting on a pension plan committee, this is probably something you would have been made aware of, but if you haven't seen this, you should be aware of it. And here's how it goes. A pension plan has to typically, the single employer pension plan has to buy insurance coverage from the Pension Benefit Guaranty Corporation, PBGC. And that cost is a per participant charge that everyone pays. And then if you're underfunded, you have to pay what's called a variable rate premium. You have to pay a risk-related premium. In other words, if you're underfunded, you got to pay even more for coverage because you're underfunded. So in this example, suppose I've got a pension plan that's got $200 million of liabilities and $170 million of assets. It's in essence 85% funded, which is not that unusual number, 85% funded. And they're underfunded by $30 million. The variable rate premiums that sponsor has to pay end up being about 4.5%. It is 4.5% of the underfunding, or about $1.35 million in 2020 alone. So you don't get any more coverage for that extra $1,350,000. It's just a additional charge you pay for being the sponsor of an underfunded plan. So we can go to the next slide. So what we're seeing is some clients are saying, you know what, we're credit worthy. Why don't we borrow and fund into the pension plan the underfunding? So in this example, suppose I did that. I'm the sponsor. I borrowed $30 million. I'm credit worthy. Put it into the pension plan. I save immediately that year $1,350,000 of PBGC premiums. Now I've got the cost of borrowing, but if I'm credit worthy, maybe I'm on a LIBOR rate. Maybe I have to charge. I only have to pay 3% on an annual basis for the interest on that note. And at the same time, I've got use of the money now. I put it into the pension plan, and even conservatively invested with an expected return of 4%, I get a little bit of arbitrage, meaning I'm paying the bank 3, I'm earning 4. That's true arbitrage. And so I have borrowing costs of $900,000. I have expected return on the pool that I've now put into the pension plan of $1.2 million. I add it all up, and just from borrowing and funding, I'm ahead $1,650,000 that year and every year in the future. And at the same time, if you're a for-profit, putting that $30 million into the pension plan results in a tax deduction. And so you've got this annual savings, number one, that's worth doing. And then on top of that, you get the government, if you're a for-profit entity, the government's paying for some of this as well by a reduction in your income taxes for that year. So if we go to the next slide, please. So I bring this up because the low interest rate environment, some people might say, is this as low as we can go? And if you look historically, it's like a 200-year low in 10-year treasuries. We got into less than 1% 10-year treasuries. And I would say, okay, it depends if the Federal Reserve is going to stick to their knitting. They have said that they're not going to go below 0. And I bring up this slide because it's kind of hard to see, but there are countries in the world, Germany and Japan being 2 of them, where interest rates are actually negative. It's kind of hard to believe, right? Negative. Doesn't make any sense. I'm gonna lend somebody some money, and then they're gonna pay me back less than what they've borrowed. That's what negative rates really are, right? They're negative interest rates. So our Federal Reserve says they're not gonna go down that path. And as a result, they've said, we're gonna stay at 0 for a few years at least. And they said we're not going to go negative. But other parts of the world have gone negative. So we'll see. We'll see where it goes. If they're truly being honest about this and saying we're not going to go negative, then we're in a environment where interest rates will stay level at best, and then in theory start to rise over time. So we go to the next slide, please. So what does that do? What does that do in terms of investing for the future? And what I've got on the left-hand slide here is a mix of a typical portfolio, which might be 60-40, 60% equities, 40% bonds. And over a 100-year period, the returns on equities were historically 10%. And fixed income was 5%. And if I had a 60-40 mix, I might be able to go through this multiplicative process and get to, well, I'm going to get 60% of the portfolio earning 10, 40% earning 5. You add it all up, and my expected return would be about 8%. And that's where a lot of sponsors of pension plans were for the last 20 years, 30 years. However, in this low interest rate environment, we're already starting to see that certain investment advisors are saying, well, maybe over the next 10 years, return on equities are going to be more muted, more like 8%. And the fixed income returns with low interest rates where they're at currently, you're probably just going to get the coupon, meaning the interest rate on the bonds at best, that's 2.5%. And you add it all up, and you're likely, with a 60-40 portfolio, likely to be more in the 6% or even a little bit less investment returns for the next 10 years. That's what we're seeing. And I'm not an investment professional. I just listen to what those who are saying when I sit in on meetings. And as a result, some sponsors are taking more risk, okay, because they're trying to get to higher rates than 6%. So we go to the next slide, please. So here are some comments. If you're a pension plan sponsor, will accountants require adjustments to the determination of book expense? Meaning, should you have to use a lower return on asset assumption? We've seen that the last couple of years. Will it continue? If you're involved with a not-for-profit, is your spending policy, is that going to get changed to something less than 5%? That's a typical spending policy. Is that warranted still if expected returns are going to be lower? And then for individuals, does a 5% drawdown rate, which is what we've seen a lot over time, maybe, and I've heard some folks say, well, maybe it should be 4. And in any event, it's something that has to be considered. If we go to the next slide, please. I'm just going to quickly go through this, just to give you some food for thought. I'm going to kind of race through this. If you go back to 1980, Treasury debt in the United States was $1 trillion. We're approaching 28 trillion. Okay, go to the next slide, please. Our federal debt, the Treasury debt, as a percentage of gross domestic product, go back to the early 80s, it was in the 35% range. Today, we're over 100%. The question is, can the Federal Reserve, can the federal government as well continue to run big deficits and pile on? And some people on one side say no. Other people on the other side say, let's go to the next slide. So other people say on the other side, look at Japan. They're at 200% plus, and they're not that different than the United States, meaning they have their own currency, okay? They're stable. They have great companies and workforces and so on. Japan's gotten to 200% plus debt as a percentage of GDP. So will we go down that road? I don't know. I'm just giving you some food for thought. So if we go to the next slide, please. This is the Fed's balance sheet. 2008, $1 trillion, financial crisis. They take it up to $2 trillion to try to prop up the system. Get up to over $4 trillion over the years. And then in 2018-19, they were trying to normalize things by reducing their balance sheet. So that just before COVID, we were having some hiccups. And then COVID hits, and they've taken their balance sheet up to over $7 trillion. The only thing I have confidence in saying about the Fed is they've gone from $1 trillion to $7 trillion plus in 12 years. That's a seven-fold move. I can tell you this, I do not see them having any possibility of doing another 7 times move in the next 12 years. That would take their balance sheet to 50 trillion. That means they're going to own everything in the United States, and that's not going to happen. Okay. So if we go to the next slide, please, I'm going to wrap up and get to our polling question in a second. If you're a defined benefit plan sponsor, you're underfunded. Does it make sense to borrow and fund the plan? It's important to discuss expected returns with your advisor consultant. And the wild card here for funding in the next few years is there going to be interest rate relief, extended amortization relief for unfunded liabilities? There were 2 parts of bills, the bills that were passed that gave stimulus and unemployment benefits. The last 2 go-arounds, they included this, but then were pulled out of the Senate bill. Who knows if we're going to get it, but stay tuned. Next slide, please. For individuals, investment returns are likely to be muted and volatile for the next 10 years. But at a minimum, you should talk to your advisor, financial advisor. Will phased retirement make sense? We'll go to the next slide, please. If you're an HR professional, it's going to be more and more the norm that phased retirements, instead of being one-offs, you're going to see more people wanting to do this. Meaning, can I go part-time? And with a workforce that, baby boomers are retiring, it may behoove many sponsors and employers to want to keep people on as part-time going forward to not lose that organizational expertise. And finally, the guaranteed income stream of a DB plan may look to be more and more beneficial going forward. So with that, we're going to poll everyone. Have you personally found the low interest rate environment, A, beneficial? Why would it be beneficial? You're buying stuff. You're borrowing to buy. Is it challenging because you're saving for retirement and or saving period and investing? Is it both because you're doing both of those things? Or is it neither? You really are unaffected. You just kind of do your plan and you stick with it and you don't worry about it. So with that, we'll ask everybody to submit and then we'll see some results. So I don't know if we're going to pull up the results or not.
People are still answering.
Okay, we'll give you a few seconds and then I'm going to turn it over to Kristen Walters in a second to do her slice of the presentation. So it'll be interesting. I'm very curious to see how people are going to respond to this because in general, people tend to say interest rates being low are good. It's great, but are you being challenged? And what we've got is the 47% didn't answer at all, but we have had the plurality finding it both. And that's how I answered as well. I answered that it's both. So, and with equal numbers finding it beneficial to those being challenging. So I thank you for participating. We may have some time for a question and answer at the end. But with that, I'm going to turn it over to Kristen Walters, who's going to take it through her presentation. Thank you for listening.
Thank you, Vincent. And hello, everyone. Happy to be here with you today. My name is Kristen Walters. I'm a partner at Mazars and the Employee Benefits Audit Practice Leader. Today, I'm going to focus on 401k plans and what plan sponsors need to know in a COVID environment. Next slide, please. The primary 3 areas we'll discuss are focused on the CARES Act, the Employee Benefits Security Administration, or EBSA, Disaster Relief Notice 2020-01, and other COVID-related plan trends that we are seeing and that you may need to be aware of and plan for. Next slide, please. As I'm sure most people on this call are aware, the CARES Act was passed late March 2020. It was recognized that because of the pandemic, people may need increased access to their retirement plan savings. So there were various provisions added to loosen restrictions related to qualified employee benefit plans under ERISA. Next slide. There are 3 main provisions related to 401k plans included in the CARES Act. The first is a coronavirus distribution of up to $100,000 with some unique repayment provisions. Loan provisions were expanded to increase the available amount from 50% of a participant's vested account and a max of $50,000 to 100% of the participant's account balance and a max of $100,000. Also, loan repayment terms were extended up to 1 year. Lastly, there was a waiver of minimum required distributions. The only required provision that needed to be adopted by plans was the required minimum distributions provision. Next slide, please. Just wanted to give some context on what some of the larger 401k providers have been seeing as it relates to the coronavirus distribution provision. ADP saw that 17% of distributions applied for between April 6th and June 26th were coronavirus distributions. Fidelity saw that 3% of individuals on their 401k plan platform, or about 711,000 individuals, took CARES distributions between April 1st and June 30th. And Vanguard saw that 2% of 401k participants took CARES distributions through May 31st. Of the Vanguard CARES distributions taken, approximately 4% were for the maximum amount of $100,000. You know, when you look at this information and knowing how large these providers are, it doesn't appear to be a very significant number of individuals who were taking advantage of the provisions. With that said, at that point, the impact of coronavirus was still most significant in certain regions, and we are now out to November with many more locations impacted. So I would expect to see some of these numbers rise. Even with the low rates noted, the provision provides for some unique record keeping or may have an impact from an audit perspective if your plan is required to have one. In my following slides, I'll aim to point out some of those unique considerations. Next slide, please. Plans have to formally adopt these provisions no later than the last day of the plan year beginning on or after January 1, 2022. Many of the provisions are optional, as I said before, and you should make sure you have a clear understanding of what was adopted. Because of the extended time period to amend the plan, there may be certain circumstances where a plan is operating with these provisions but not formally amended, creating some confusion. Also, amendments were rolled out in various ways by third-party administrators. Some have required a signature to adopt and enact the provisions. There have been some that have indicated that if there was no response, they would be adopted and started operating accordingly. Again, very important to know specifically what your plan has adopted. Next slide. There were some key points or clarifications that were discussed in an FAQ release by the IRS on May 4th regarding the provisions. It was noted that with the exception of the waiver of required minimum distributions, the remaining provisions are in fact optional. Also, you do not have to adopt the provisions in their entirety. There's some flexibility there. Again, another reason why you really have to pay attention as to how the plan is operating and what may be going on and how to plan from that from an administrative standpoint. In terms of eligibility to receive these benefits, ordinarily the request from a participant would need to be evaluated by a third-party administrator or the plan sponsor for eligibility, but the IRS permits in the instance of coronavirus-related criteria that a participant can make a self-certification and that the plan administrators can rely on that certification. This was an area that was somewhat of a question that was confirmed in June. Also, if a misrepresentation was made by a participant as to their self-certification, it should not cause the plan to be disqualified unless the plan administrator is aware that they didn't qualify. These distributions are not subject to income tax withholding at the date of the distribution, and they do not have the early withdrawal penalty. Along with the distributions, there is an option by the participant to repay the funds over a 3-year period. This has been noted to be structured as a qualified rollover. So the repayment can go to any qualified plan. So if you don't want to amend your plan to accept rollovers, if it doesn't already have that feature, the participant can roll the funds into another plan to satisfy that repayment requirement. We're going to jump into a polling question here. Next slide. So did your employer's 401k plan adopt A, none of the CARES Act provisions, B, all of the CARES Act provisions, C, some of the CARES Act provisions, D, there is no 401k plan, or E, I am not sure? We're going to give you some time just to answer that, and then we'll see the results. I am seeing a pretty big disparity in my clients on what's happening. A lot of them are being very careful in the options that they choose so that it doesn't, everyone's operating remotely and trying to administer new provisions can be difficult. So I'd say from what I'm seeing, there's a lot of some of the CARES Act provisions are being adopted. And that looks like what the poll results are showing as well. Okay. Next slide when we're ready. We're going to discuss some key points that came out in the EBSA disaster relief notice. This was a joint notice coordinated with the DOL, Department of Treasury, the IRS, and the Department of Health and Human Services. A lot of the information contained in here was to align with or allow for the provisions released in the CARES Act. We're going to focus on some of the other items in there as well that provide some flexibility. Because of COVID, the Department of Labor has acknowledged that there may be some temporary difficulties for employers to meet certain requirements and have addressed some of those matters. The alleviation that is provided is effective from March 1st, 2020, which is considered the beginning of the national emergency, until 60 days after the announcement of the end of the national emergency or another date announced by the department in a future notice. So nothing's been announced as of yet. Next slide. In this notice, there was an extension of timeframes established for certain required deadlines for notices or disclosures to plan participants, predominantly those that are covered under Title I of ERISA. This includes items such as the summary plan descriptions, summary of material modifications if applicable, individual benefit statements, and the summary annual report. So they're providing some relief in the time frame or the delay of delivering those materials to participants if it's COVID related. Next slide. Notice also states that the department will not consider it a plan failure if there are delays or changes in the procedural requirements for plan loans or distributions that do not comply with the terms of the plan if the failure is solely attributable to COVID. So what you'll see a lot throughout these notices is that it has to be COVID related and documented accordingly. The plan administrator, they're still required to make a good faith, diligent effort under the circumstances to comply, and they must make a reasonable attempt to correct any procedural deficiencies, such as maintaining documentation, et cetera, as soon as administratively practicable. Next slide. So I know this is a lot of words on this slide, but essentially, as I had indicated in the beginning, this really is just to align the loan provisions with the CARES Act so that it's not deemed a failure to comply. Next slide. So this section relates to remittances to the plan for participant contributions and loan repayments. The department has provided some flexibility in the time period for which these remittances can be made as it relates to difficulties that may be encountered due to COVID. So similar to that, it has to be COVID related. Generally, the rule of thumb is participant contributions and loan repayments must be remitted to the plan as soon as the assets can be reasonably segregated from the employer's general assets, but no later than the 15th day of the month following the month in which the funds were withheld from the participant. This is typically evaluated based on the plan, when the plan sponsor can actually demonstrate their ability to make those remittances. So, you know, when they say as soon as possible, if it's an automated process and it takes you 2 days, that would be what they're looking for as a demonstrated ability to remit the funds. So, you know, if you have multiple record keepers or multiple platforms and you need to do some administrative work to remit those funds, then that typically might add a day or two to the time period. So if you're in an examination, that's usually how they come to the basis of what's considered late. So on the next slide, I'll walk through a depiction of what all these words mean and show you a little bit of a timeline on where there's some alleviation in this criteria. So the top timeline or example shows the typical scenario, which we just walked through. You know, if the pay date or withholding takes place on March 15th, the plan sponsor would be required to remit the funds as soon as possible, which in this example, we show a couple of days, but no later than April 15th. under the notice and what is demonstrated in the second example, or the relief period, beginning March 1st, 2020 and ending on the 60th day following the announced end of the national emergency, the department will not take enforcement action with respect to a temporary delay in forwarding remittances to the plan. If these delays are, again, solely related to COVID. Employers and service providers must act reasonably, prudently, and in the interest of employees to comply as soon as administratively possible. I just want to emphasize that if the delay is not related to COVID, you still have to make it as soon as possible, and you still need to meet the same criteria, but you should be aiming to stay on your normal course or schedule. And if you do have something that comes up because of COVID and working arrangements or someone being sick and out because of coronavirus, you'd want to make sure that that's documented so that if you do have an audit, it's explainable and you have that right there to provide to them. Next slide. In the event a blackout notice needs to be provided to participants, which is a required 30-day advance notice when a participant's rights will be temporarily suspended or limited to their accounts. This is usually due to a change in TPA or some other matter like that. A plan sponsor may not need to meet this time required under the notice due to the pandemic. For instance, when there was no access to the office or it's difficult to administer a paper mailing of these notices, and if that's what your employee class is predominantly getting this information in the mail, that might be a scenario that falls under this exception. Next slide. Overall, the guiding principle for plans must be to act reasonably, prudently, and in the interest of covered workers, and make reasonable accommodations to prevent the loss of benefits. This should be the default mindset when administering the plan during these very difficult times. On the following slides, we're going to discuss some more of just some related plan trends that we're seeing, not necessarily related to notices coming out or FAQs, but more what's expected based on these new provisions or layoffs and other matters. Next slide. Actually skip again. Thank you. So due to certain industries being significantly impacted financially, there's a pretty large expectation that we'll see a decrease in discretionary employer contributions. Typically, all that's needed by the employer is to document that these contributions will not be made in some sort of corporate documentation, whether it be minutes or a memorandum. In the instance where there are mandatory non-safe harbor matching contributions noted in the plan document, the match can be suspended, but the plan does need to be amended in order to discontinue the contributions, and the plan sponsor should continue to make those contributions until that effective date. Next slide. There are many plans that have a safe harbor plan design where there's a safe harbor matching contribution. Oftentimes this is done to enable the highly compensated employees to contribute the maximum amounts permitted by the IRS, and the plan is automatically deemed to pass ADP, ACT non-discrimination testing. So if a company is struggling to make these contributions, there may be some ways for an employer to reduce or suspend them. The first option is if the employer can demonstrate that it is operating at an economic loss. And the second option is if the employer has included in the annual safe harbor notice a statement that the plan may be amended in the upcoming year to suspend or reduce safe harbor contributions after a 30-day notice to participants. Now, if this happens and you move forward with this route, the plan does become subject to ADP, ACT testing, so that may impact some of your highly compensated employees, and this whole change really needs to be very carefully considered. Next slide. So many companies have had a series of furloughs, which could significantly impact certain participants that have outstanding loan balances. Under IRS regulations, employees with loans placed on unpaid leave may be able to avoid default in the taxable event if the furlough period is not in excess of 1 year, and the loan would need to be repaid by the end of the original term. So that may include them making a one-time catch-up payment for payments missed if it's a short time period, or re-amortizing the remainder of the loan balance to the original term when and if that person resumes work. As it relates to terminating employees, employers can consider permitting them to repay 401k loans from severance. Obviously, this isn't a standard practice, so there is an administrative function to that, so that needs to be considered. And you also need to think about who's really receiving severance pay. Is it only highly compensated people, or is it across the board? Because then you could run into some non-discrimination issues. Next slide. Overall, loan defaults are expected to be higher in 2020 and 2021, based on some of the things we just touched on, but also due to this increased limitation permitted under the CARES Act. So there's some speculation that this may continue to be an issue in many subsequent years. So great care should be made to explore all relevant options with participants so that they're not put in a more difficult financial situation, to the extent that you're able to do so. Next slide. Another area where we expect to see employers proactively evaluating with their ERISA attorney is whether a partial termination has occurred. So generally speaking, the IRS considers a turnover rate of greater than 20% to be the basis for a partial termination. When a partial termination occurs, participants become fully vested in their contributions. With that said, there are a variety of other aspects to consider, such as furloughed employees, time period of furloughs, rehires, and some other matters. It is important you are consulting with your attorney to determine if you're at risk, particularly if you have a vesting schedule related to your employer contributions. Next slide. In a recent FAQ issued by the IRS, they did provide some additional guidance to consider related to partial plan terminations, including where to find guidance on the applicable period to monitor and what would be included in the turnover rate calculation. As I mentioned previously, if you believe you're at risk here because you did have significant layoffs or turnover, you should be consulting with your ERISA counsel. Overall, there's a lot of unique things to consider and keep a handle on, but I would add to consult with your service providers, accountants, and attorneys so that you're focusing on the right risk areas and do not run into any problems on the administration side, plan qualification side, the audit side, and all those regulatory type of items. Thank you everyone for your time today. Happy to answer any specific questions at the end that may come through. And I'm now going to turn it over to Ben Spader.
I think you're muted.
Thank you, Kristen, and good day, everyone. My name is Ben Spader, and I've been working with defined benefit plans since all the continents were a single landmass, so for a little while now. So let's talk briefly about DB compliance in the age of COVID. Next slide, please. So I asked myself, what do we need to know about compliance today? And I found a list of the top 10 issues identified by the IRS during examinations of defined benefit plans as of March 17, 2020. So what's significant about that date, March 17, 2020? Well, it's just a handful of days before most of the country entered its first shelter in place. How is that useful to us? And how is this list useful? Well, I can assure you that none of the compliance issues that were prevalent immediately before COVID are any less prevalent during COVID. In other words, DB compliance does not now become a new priority when the world is falling apart. So I believe we can count on having these same issues confront us today, and it's useful to know what the IRS is looking for, the last thing they've seen, so we can identify any failures we have before the plan is audited. And that's really important. So if the IRS finds one or more of these issues on audit before we've identified and corrected them, COVID or not, the sanctions can be enormously expensive. For large plans, this can result in hundreds of thousands of dollars in sanctions or more. Moreover, there is limited flexibility of your correction methodologies when you are under audit. So the IRS identified 5 categories of errors. operational errors, which are generally a failure to follow the plan terms, demographic errors, which is generally coverage or non-discrimination errors, plan document errors, which is when plan terms are non-compliant with the law, funding errors, which are generally self-explanatory. They're too little or too much funding, and other errors, which is one issue that I was surprised to see that we'll speak about in a moment. So I think we can switch slides now. All right, so let's look at some specific errors. Starting with the operational errors, the first is a failure to obtain spousal consent for non-qualified joint and survivor annuity forms of payment. And the correction for failure to obtain consent is generally a choice between providing the consent for the distribution actually made, or one, receiving a qualified joint and survivor annuity, or two, receiving a cash out of the present value of the QJSA. Next, the IRS found plans frequently fail to pay minimum required distributions. Generally, the correction is to distribute the missed MRDs plus interest. The third item is a wealth of benefit calculation errors that are integral to DB plans, such as failure to actuarially adjust benefits after age 65. That's a biggie. And using the wrong credited service values or using the wrong reduction factors. In each of these cases, you will likely have underpayments or overpayment corrections to be made by following EPCRS. Next are participant loan errors, which come in every flavor, from no plan provisions to excessive amounts to excessive repayment period to no level amortization, virtually everything. And these are all correctable to the extent permitted under VCP, generally speaking. And lastly, vesting errors also abound, such as applying the wrong schedule or the wrong percentage. The result, of course, is typically either erroneous forfeitures or the correction of overpayments. Next slide, please. Okay. Now, demographic errors. For demographic errors, self-correction is typically unavailable. Demographic errors are normally corrected only under VCP. So the IRS found that minimum coverage errors were rampant. The correction of minimum coverage errors generally requires a corrective amendment to the plan, either adding more benefits or increasing existing benefits. But if coverage errors result from the failure to include eligible participants, for example, that's different. Then that's an operational error and is typically self-correctable. Next are plan document errors, which are non or late amender category. So we've seen those before, and generally, like demographic errors, self-correction is mostly unavailable for non-late amenders, only VCP again. For non-late amenders, there are a myriad of corrective amendments and penalty schedules depending on the failure. That's a fairly new construct under EPCRS. Next, we have the funding errors, which come in the form of naturally a shortfall of funding or excess contributions. These frequently resulted from eligibility or compensation errors, and in the age of COVID, we'll see funding shortfalls from business downturns. But we won't know yet because the CARES Act funding extension due to COVID was extended until 1/1/2021. And only 2 days ago, that 1/1/2021 date, which was a Friday, has been extended to January 4th, 2021, which is now the following Monday, to give folks a chance to make those contributions in the plan year 2021, or calendar year 2021. Regardless, the consequences of these errors are potential excise taxes and loss of deductions. Now, the famous, quote, other errors, end quote, here we mean the IRS found many plans had no fidelity bond. And frankly, I don't fully understand why the IRS looks for this error, but presumably it's just so obvious on the 5500. But do you think the Department of Labor would have already phoned you by the time the IRS starts looking at your 5500? Anyway, There is no correction for no fidelity bond, but if you get a fidelity bond before it's discovered by proactively reviewing your plan, as we talked about, you might avoid a referral by the IRS to the DOL where they might look more closely under the plan's hood, which is, of course, a very undesirable result. So with that, let's go to the next slide, and I think we have a polling question. So I'd like you to think about, as a result of the COVID crisis, we can expect compliance issues to be minimized, true or false. And while you are providing your answers, I'll mention that an interesting thing I found as well on the compliance front is that for frozen defined benefit plans, the IRS was expecting to see a lot of things, particularly non-amenders. But what they found most of all was 5,500 errors, which is something, I guess, a little bit surprising. But if you have a frozen defined benefit plan, having your advisor or a second advisor, other than the perhaps record keeper, review that 5,500 is probably a good idea, because errors in the 5,500 can cause some knocking on your door, which we don't want. So I think we have some results here, and I think that this was intended to be false, and I think that we're going to have many of the same compliance issues that we had immediately before COVID, and we can expect to continue those, but we can protect ourselves against them by simply reviewing, understanding what these issues are, making sure we hit all the, at least the big targets, now that we know what the targets are. And on that note, I'd like to turn it over to Candace.
Labor's final rule on fiduciary investment duties and review recent developments on data privacy and cybersecurity issues concerning ERISA plans. Next slide, please. Now, ERISA requires that fiduciaries act with the exclusive purpose of providing benefits to participants and beneficiaries and defraying reasonable costs for administering the plan. And ERISA requires fiduciaries to invest with the care, skill, prudence, and diligence for a prudent man acting with like character and like aim. Next slide, please. Now, for a brief background on the DOL's investment duties rule, we go back to April 2019. The President issued an executive order instructing the Department of Labor to study ERISA plans as to investment trends in the energy industry and policies promoting long-term investment growth and maximizing returns on plan assets. Then in July 23rd, 2020, the DOL issued a proposed rule amending fiduciaries' investment duties regulation. Now, the proposed rule required fiduciaries to act solely and exclusively for the purpose of providing benefits to plan participants and beneficiaries, and the rule requires the fiduciary not subordinate the economic interests for policy goals such as economic, social, governance, or ESG objectives. The DOL received some 1,500 comment letters regarding that proposed rule. And then on October 30th, 2020, the DOL issued a final investment duties rule. Now, the final rule removed the mention of ESG, but stressed that fiduciaries must satisfy their duty of prudence, and they must act exclusively to focus on economic interest in investment decisions. Now, the rule becomes final January 12th, 2021. Next slide, please. The rule provides new additions to the existing fiduciary duties rule, and it provides factors to consider if there's a tiebreaker and what needs to be documented by fiduciaries in the case of a tiebreaker. The rule also applies to defined contribution plans, but not brokerage windows. And qualified default investment alternatives, or QDIAs, must not consider or include any non-pecuniary factors. And plans that have QDIAs have until April 30th, 2022 to comply with the QDIA requirements. Next slide, please. With regard to the duty of prudence, the rule provides a new definition of pecuniary factors and it also provides guidance with regard to the weight given to these pecuniary factors. And next slide. With regard to the duty of loyalty, the rule provides that in evaluating an investment, a fiduciary may not subordinate the interest of retirement income for other objectives, and they must not sacrifice investment return or take on additional risk to promote non-pecuniary benefits. Now, in the case of tiebreakers, the rule provides for factors to consider and what needs to be documented. Now, the documentation required in the rare case that there is a tiebreaker, and this is where it is truly indistinguishable between investments based on fiduciary factors. Now, in this case, the fiduciary must note why the pecuniary factors were not able to be sufficient in selecting the investment, how the interests compare to the alternative based on the factors required in the rule, and how the chosen non-pecuniary factors are consistent with the participant's beneficiary interests and retirement income objectives under the plan. Now, under a Biden-EPSA, the rules could be reviewed. But as the final rule becomes effective on January 12, 2021, fiduciary should review its requirements for compliance. Okay. ERISA fiduciary breaches. Next slide, please. In the U.S., retirement plans, savings, and defined contribution plans and 401ks have grown to over $6 trillion. Due to the significant amount of funds invested in these plans, they are a target for theft, both identity theft and fraud transactions. And we're seeing an increase in ERISA class actions with regard to issues regarding selling confidential participant data. And ERISA is silent on data protection in the form of electronic records. And there is no comprehensive federal statute governing cybersecurity, and recent ERISA litigation has made allegations that confidential information such as participant contact information, fiduciary data, investment preferences, data of retirement is being cross-marketed without their knowledge. Next slide, please. ERISA does not specifically address if participant data is a plan asset protected under ERISA, but the Department of Labor has directed plan administrators to take action to protect the confidentiality. Now, monetary assets are plan assets, and they must be protected from theft, including cyber breach. Whether a failure to protect retirement plan financial data could result in a fiduciary breach depends on whether the financial data is considered a plan asset. Now, it's the DOL position that the asset should be identified based on notions of property rights, based on a 1992 DOL advisory opinion. Now, there are several different tests that could be applied. Due to the focus on the value of personal data in our current society, a recommended approach is to take careful steps to protect that data. Yet ERISA class action continues with allegations that of a failure to safeguard the confidential data. Next slide, please. So what has been the result? Well, there's been a settlement in which the sponsor agreed to not disclose the plan fiduciary, and record keepers would not disclose without participants' approval and request. And in other cases, it was determined that participant information was not a plan asset, relying on DOL's notion of property rights. In our next section, Ada Dolph will discuss these cases in more detail and the trends in ERISA litigation. Next slide, please. So what can a fiduciary do? There's no federal statute specifically addressing cybersecurity. And while ERISA was enacted in 1974 and is silent on data protection, yet a majority of states have privacy and cybersecurity statutes. While in the interim, a fiduciary has strict fiduciary duties of prudence and loyalty. And as the ERISA class action continues, what should a fiduciary do? Well, next slide, please. A fiduciary should take steps to protect the data. They should be educated on the law, and they should negotiate cyber protection in the contract. They should make sure that it is a contract and it's not just marketing material. And ERISA counsel can be helpful in evaluating that, as well as RFPs to third-party providers. Fiduciaries should be careful that there's not cross-marketing of private data, and they should limit access to participants' data. And a fiduciary needs to understand the internal risks associated with transmitting data and be mindful of their ERISA duties. So this concludes my presentation, but I see we have another polling question. True or false? ERISA does not specifically address if the participant data is a plan asset protected under ERISA. Please select true or false. And I would note that as ERISA was enacted in 1974, it's hard to imagine that legislators could have ever dreamed that one day the value of data could be what it is today. So it is of interest how things have changed since 1974 when ERISA was enacted. As we're waiting for the results, I see the answer is true, which is yes. It does not specifically address it. So with that, I'd like to turn it over to Ada Dahl to talk about trends in ERISA litigation. Thank you.
Thank you, Candace. And I know we're near the end of our time, so I'll do an abbreviated review of the class action litigation that we've been seeing in this area. I'm a partner in Seyfarth's Chicago office, and I do a tremendous amount of ERISA class action litigation defense. And we're seeing some trends this year that started up late 2019 that I want to make sure everyone's aware of and paying attention to, and circling back with your administrative committees to make sure that they're dotting their I's and crossing their T's. So this slide here, and we'll go through the next few fairly quickly. This is some data that we've assembled as a firm. Every year we prepare a class action report, and it comes out in early January. We're already preparing the one for to come out in 2021. But what we saw in 2019 was a continuation of trends that have continued over the years in this area. In general, ERISA class actions tend to be certified more readily than other types of class actions because of the uniformity in the participant experience. The same investment menu, for example, is offered. The same number and type of communications are sent to them. And those similarities lend themselves to relatively easy class certification. You can go to the next slide, please. The next slide just shows you in which jurisdictions we saw in 2019 the certifications. Next slide. And this is no small player in the class action area. So you can see here from 2019, the amount paid in ERISA class action settlements. Next slide, please. And this, again, provides some more information on the size of the settlements. The largest in 2019 was $80 million. What I would say is for a period of, I don't know, 10 to 15 years or so in the ERISA class action area, the largest plans have been targeted because of the size of the fees at issue, the ability for plaintiffs' counsel to recover massive attorney's fees and those sorts of things. But what we're seeing now is a pivoting from the largest plans to mid-size and smaller plans. And some of those plans, in my experience, have less outside advisors, less experienced administrators, and can get caught up in some of these sort of hindsight analyses about the oversight of the plan. So it's particularly important that if you're a mid-size or smaller plan, that you pay attention to these issues as well, including everything that was discussed by the team today. Next slide, please. Next slide. So one area that Candace touched on, and we're seeing a growing area of litigation, is with cybersecurity and data privacy. And certainly plan administrators, plan sponsors, and service providers are not immune from the cyber attacks that have been increasing in volume. So we're seeing some litigation come out of these. Typically, it's a situation where someone is impersonating a participant and engages in identity theft. You have a distribution come out of a retirement account that was fraudulent, and then the participant sues. And because of lack of clarity in the law, it's the plan sponsor, that is the employer or company, can be sued. Next slide, please. We're seeing in those instances where a service provider is the primary actor in the distribution that they have at times countersued the plan sponsor arguing that the plan sponsor did not have enough security around, for example, remote work policy. So this is something to pay particular attention to, given so many employees that normally are not working, we're not working remotely is to pay attention to your security around access to your benefit information, your benefit platforms, because just because it was handled exclusively by a service provider does not mean you will be off the hook as a plan sponsor. And also what we're seeing is a trend of state law claims being permitted to proceed and not being viewed as preempted by ERISA, potentially allowing double recovery. So here, it's important to remember there's co-fiduciary liability under ERISA. There's also failure to monitor liability. So if you delegate a fiduciary duty to a service provider and the service provider engages in a fiduciary breach, you can be held liable if you did not do enough to monitor that service provider's performance. And we're seeing the cases where the service providers have argued that a ministerial exception should apply. The courts are not, at least in the early stages of those cases, allowing that to happen. Next slide, please. I'll touch on this briefly, but we've seen this each time there's been an economic downturn or volatility in the market. With steep drops in company stock prices comes additional stock drop litigation. There's a Supreme Court case that tightened up the pleading around this type of case that was once one of the most prevalent types of ERISA class action being filed. That there's been a significant decline in these, but we do expect with the market volatility and opportunity for these cases to continue to increase. So something else to pay attention to. If you have a lot of volatility in your company stock fund, consider involving an independent fiduciary to manage whether you need any restrictions around that for your participants and that sort of thing. But these are the types of claims that we're relatively familiar with, so we'll go to the next slide, but something to pay attention to. The main one I wanted to hit on with everyone today is an absolute dramatic increase in the amount of 401k and 403b plan fee litigation. I would say it's probably a tenfold increase over prior years. And again, the targets for these are mid and small sized plans, which is new. What we're seeing is a new set of sort of consumer class action plaintiffs' counsel get into the business of filing these lawsuits. So when an employee comes into their door disgruntled about being furloughed, about being laid off, which again, you know, with increases in separations of employment, we always see an increase in this type of litigation as well as employment litigation generally. And we're seeing a lot of firms who have never filed these types of cases file 2 to 3 a month against some new target, because it is much more profitable from an attorney's fees perspective to get a class together. Again, you can almost be, from a plaintiff's counsel side, guaranteed class certification of some group. And the other trend that has caused an increase in these is that the courts have been extremely reluctant to kick them out early in the case in motion practice. So defendants are in a situation where it's going to be very costly to defend. So they've also been, these new consumer class action type plaintiffs firms have been getting involved, very interested in settling them. But what it means is we are just seeing more and more of these being filed, and we expect that to continue. Next slide, please. And this just gives you some more information about the types of claims you can anticipate seeing. I would highly recommend, if you haven't taken a look at your plan governance, to engage counsel who's experienced in plan governance and ERISA litigation to give you some points on whether the governance you have in place and the monitoring of fees and investment selection you have in place is sufficient under the current state of the law. Next slide, please. 2 other quick ones I'll touch on, and these kind of go to some of the things that were talked about earlier by Vincent. There's a growing area of litigation around the mortality table that is used in converting a participant's single life annuity into another form of benefit. There's a healthy amount of debate happening in the courts right now, so it's difficult to make a decision as a fiduciary about what to do, but your fiduciary should be paying attention to this and monitoring this, particularly if they are cited in a jurisdiction that looks like they're going to have some issues with the mortality table that's being used in the plan. Next slide, please. And we're also seeing an extreme amount of COBRA notice litigation. Again, as a plan sponsor or employer, and for service providers, don't assume because you've delegated it off to the service provider that the notice would be viewed as sufficient. Some of these class actions are challenging even the use of the model notice, which is ridiculous at some level, but we are definitely seeing that. So take a look at your COBRA notices and make sure that those are compliant. And with that, I'll turn it back over to Candace.
Thank you very much, Ada. Well, I'd like now to provide the CLE code, and it is SS7012. That's SS, like Seyfarth Shaw, 7012. And with that, I'm going to turn it over to Morgan Curry to provide the closing comments for the webinar. And thank you all very much for joining today, and please stay safe. Morgan?
This concludes today's webinar. As a reminder, our speakers will follow up via email to questions we received in the Q&A chat, and you will also receive a CLE affirmation form via email following the program. Thank you for attending.